Greetings, and welcome. For those of you aspiring to establish the United Kingdom as your permanent residence, or who hold the ambition of attaining British citizenship, the following information is of paramount importance. The landscape of UK immigration is in a state of continuous transformation, and the year 2025 is anticipated to introduce some of the most substantial amendments in recent memory. Remaining well-informed is not merely a suggestion, it is a critical component for the success of your application. Today, we will explore 5 significant new regulations concerning indefinite leave to remain, also known as ILR, and British citizenship that are essential to understand in 2025. We will examine the specifics of these changes, clarify their potential impact on you, and provide practical guidance. So, please make yourself comfortable as we begin this important discussion. First, let's address the proposed extension of the qualifying period for indefinite leave to remain. A pivotal change for many individuals on the path to settlement is a proposal from the UK government to considerably lengthen the standard qualifying period for ILR. For numerous visa categories, the existing requirement is 5 years of continuous lawful residence in the UK. However, new proposals suggest this could be extended to 10 years. This signifies that for many people holding work visas, the journey to permanent residency could potentially double in duration. The government's stated reason for this potential change is to ensure that migrants have formed more profound connections and made a more significant contribution to the UK before being granted permanent status. It is crucial to understand that these proposals were introduced in a government white paper, meaning they are not yet law and are subject to modification. The government is also considering a system of earned settlement, which could allow certain individuals to qualify for ILR in less than 10 years through a points-based system rewarding contributions to the UK's economy and society. Factors such as employment in priority sectors, higher tax contributions, and community involvement might be taken into account. What does this mean for you? If you are at an early stage of your visa process, it is advisable to monitor these developments closely. Should these changes be enacted, you may need to prepare for a significantly longer period of temporary residency before becoming eligible for ILR, which could affect your long-term financial, career, and family planning. Our second point concerns a confirmed alteration that tightens the good character requirement for British citizenship applicants, which took effect on February 10, 2025. This is a critical element in the final stage of becoming a British citizen, and the Home Office has adopted a more stringent approach to its evaluation. The updated guidance indicates that any individual who has entered the UK unlawfully will typically be denied British citizenship, irrespective of the amount of time that has elapsed since the illegal entry. Previously, a 10-year period was often applied where such immigration breaches might be disregarded. This is no longer the standard approach. The new regulations also specifically address individuals who have undertaken a dangerous journey to the UK, such as crossing the English Channel in a small boat or being concealed within a vehicle. An application from someone who arrived in such a manner will also, under normal circumstances, be refused. The term normally suggests that exceptional circumstances might permit an application to be granted, but such instances are anticipated to be extremely rare. This change will have a considerable impact on many refugees who have been granted protection in the UK but may have had no alternative but to enter the country through irregular means. What is the essential takeaway from this? If you are contemplating an application for British citizenship and have a history of illegal entry or perilous journey into the UK, seeking professional legal advice before submitting your application is absolutely crucial. The criteria for this requirement have fundamentally shifted, and a refusal can be both expensive and damaging to your future immigration prospects. Third, we will discuss the escalating salary thresholds for skilled workers and for those applying for indefinite leave to remain. This is a major development for anyone on a skilled worker visa or hoping to enter the UK via this route. Effective from July 22, 2025, the general minimum salary threshold for new skilled worker visa applicants will see a significant rise to £41,700 per year. This represents a substantial increase from the previous threshold. This increase will also impact those applying for indefinite leave to remain through the skilled worker route. When you apply for ILR, you will be required to demonstrate that your salary meets the new, higher threshold in effect at that time. This implies that even if your initial visa was granted based on a lower salary, you will need to have secured a significant salary increase by the time you become eligible for settlement. salary discounts are still available for individuals with a relevant PhD or a job on the immigration salary list, but these discounted thresholds have also been increased. It is also important to recognize that while the health and care worker visa has different salary requirements, new applications for care workers from overseas will no longer be accepted from 2025. In light of this, what actions should you consider? If you are a skilled worker, it is imperative to have a frank discussion with your employer regarding your salary progression to ensure you will meet the ILR requirements when the time comes. For employers, this necessitates incorporating these higher salary costs into your recruitment and retention strategies for international talent. Fourth on our list is the overhaul of the Life in the UK test and English language standards. For years, the Life in the UK test has been a mandatory requirement for both ILR and citizenship applicants. Often critiqued for its focus on historical and cultural trivia, significant changes are anticipated. The government intends to replace the current test with a new British values test. The emphasis of this new test is expected to move from the memorization of historical facts and dates towards a demonstration of understanding the UK's fundamental values, such as democracy, the rule of law, individual liberty, and tolerance. While the precise format and content are yet to be finalized, the goal is to create a more meaningful evaluation of an applicant's integration into British society. In addition to the new test, the government also plans to elevate the English language requirements for both settlement and citizenship. The specific proficiency levels are still under review, but it is probable that future applicants will need to demonstrate a higher command of the English language. A requirement for all adult dependents of workers and students to possess a basic level of English is also being introduced. Our guidance on this matter is as follows. If you are approaching your eligibility for ILR or citizenship, it may be prudent to take the current Life in the UK test and your English language test sooner rather than later, before these new, potentially more demanding requirements are implemented. For those with a longer time frame, it is important to stay informed about official announcements regarding the new test and language levels. Our final point addresses the raising of the skill level for skilled worker visas. This is another considerable change to the skilled worker route. The minimum skill level required for a sponsored job is being elevated from Regulated Qualifications Framework Level 3, which is equivalent to A levels, to Regulated Qualifications Framework Level 6, which corresponds to degree level. This is a substantial alteration that will render a large number of jobs, previously eligible for sponsorship, no longer so. Consequently, roles in sectors such as hospitality and retail, which might have met the RQF Level 3 requirement, will likely now be excluded. This measure is part of the government's broader strategy to concentrate on attracting highly skilled individuals to the UK. For individuals already in the UK on a skilled worker visa in a role below RQF Level 6, there are transitional arrangements that may permit you to extend your visa or apply for ILR. However, for new applicants from outside the UK, the opportunity for many medium-skilled jobs is diminishing. What are the implications for prospective applicants and employers? Prospective applicants must ensure that the job they are offered meets this new, higher skill level. Employers, especially in sectors that have depended on sponsoring workers for medium-skilled positions, will need to reassess their recruitment strategies and potentially increase investment in training the domestic workforce. So, to summarize, these are 5 major changes to the UK's indefinite leave to remain and British citizenship rules that are poised to have a significant impact in 2025. From a potentially extended path to settlement to more rigorous character and skill requirements, the message from the UK government is unambiguous. The standard for permanent residence and citizenship is being raised. Navigating these changes can be a formidable task, and the implications are substantial. Our objective today was to provide you with a clear and thorough overview to assist in your preparations. We consistently advise seeking professional immigration advice that is tailored to your individual circumstances. If you found this information beneficial, please show your support, subscribe to our channel, and activate notifications so you do not miss our future updates on UK immigration. We also invite you to share your thoughts and questions in the comment section below. We will endeavor to guide you in the right direction. Thank you for your time, and we extend our best wishes to you on your journey to making the UK your home.